Lawfulness Part 1. Before processing any personal data, aid actors should carefully determine the most appropriate legal basis and the related requirements and obligations. Article 6 of GDPR requires at least one of the following bases for lawful processing: consent, vital interest, legitimate interest, contract, legal obligation, and public interest. In this video, we will focus on the ones aid actors commonly rely on for humanitarian action. Let's start with consent. Processing of personal data is lawful if the data subject has given consent for the organization to process their personal data. Consent is only valid if it is freely given in the absence of a clear imbalance of power and the subject is free to refuse and easily withdraw consent anytime. Specific to the declared processing activity and purpose, with separate consent obtained for the same activity to be used for a different purpose or for other activities. Informed with the data subject provided with complete and accurate information about the processing activity in a language that is clear and understood, and unambiguous by means of a statement or clear affirmative action. Although consent may be the most popular and often preferred legal basis for personal data processing for many organizations, humanitarian actors operating in a crisis situation may not be able to rely on consent obtained from project participants made vulnerable by disasters, armed conflict, and other emergencies. A more suitable legal basis must be used to justify data processing to support delivery of much-needed aid. In rare and specific cases, vital interest may be used as legal basis when processing is necessary to protect a person's life, health, integrity, dignity, and security, or that of another. This legal basis is used on a limited basis during life-threatening or emergency situations in which the data subject is physically or legally incapable of giving consent. Other situations may also require processing based on the vital interest of another individual, such as processing a parent's personal data to protect the vital interests of their child. It must be remembered, however, processing data using this legal basis is only lawful in the absence of another applicable legal basis and only after project participants have been adequately informed and given the opportunity to object. A humanitarian organization may process data when it is in their legitimate interest for the effective performance of their mission or as required by donors. This legal basis applies to activities necessary to improve delivery of humanitarian aid, manage risks, reduce costs, or those that data subjects may reasonably expect, such as marketing or fraud prevention. This legal basis may be relied on by a controller or a third party provided that there is no harm to the person's interests and fundamental rights and freedoms. The processing must be based on a compelling necessity, aligned with the data protection principles, and is not a matter of convenience. In summary, aid actors must carefully choose the applicable legal basis for all its processing activities to ensure that humanitarian assistance is delivered effectively and efficiently without harm to the data subjects.
Lawfulness Part 2. Humanitarian actors usually rely on consent, vital interest, or legitimate interest as legal basis for processing personal data. However, depending on the circumstances, humanitarian organizations may also rely on other legal bases, such as contract. An organization may process data when it is necessary for the execution of a contract between the data subject and the controller, including the provision of a requested service, data processing relating to employees, suppliers, etc. This legal basis does not apply to data processing for marketing, advertising, or pre-contractual measures. Legal obligation. Personal data may be processed to comply with common law or statutory obligation. This legal basis applies only if the legal provisions provide a clear purpose and a specific obligation for the controller to process such data within the bounds of a European Union or a national law to which the controller is subject. Public interest. This legal basis is commonly used by public authorities or organizations who may process data in the performance of a task in the interest of the public or in the exercise of official authority set out in law. Humanitarian organizations may only use this as basis if it is mandated to do so. Processing of sensitive personal data. Even when the organization has identified a legal basis for processing personal data, processing of specific categories of data on racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data, health-related data, sex life or sexual orientation may still be prohibited. Processing such data may be necessary under compelling circumstances, but only after an exception has been properly established. Some of these exceptions that may apply include the following: explicit consent, employment, social security, and social protection, if authorized by law, vital interests, and legal claims or judicial acts. It is important to note that choosing the appropriate legal basis for processing personal data must be done with care, as it defines the measures and controls necessary to comply with data protection laws and protect the rights and freedoms of data subjects.